one option obviously is court, and some clients when they come to see us, that's what they think they want. By the time we've explained that process properly to them and explained that a court process is something that we know is going to be expensive, we know is going to be lengthy, we can't tell you how long it's going to take, and we can't tell you how much money you're going to spend on it, and sadly we can't even tell you, if you go to court, what a judge is likely to do. We can give a prediction, and that's all it can be. You could run the same case before 10 different judges and get 10 different answers, and so there is always a huge element of uncertainty in any court process. One thing is certain, and that is the damage that the court process does to families and relationships, whether that's a business partnership, whether that's two brothers fighting about their mum's estate, whether it's a husband and wife who still need to be able to co-parent their children after the dispute is over. If you go to court, what we know is it's going to polarise those relationships, and it's going to create the potential for ongoing resentment and disharmony. We also know that the outcome of a court process and the judgment that's delivered sometimes is a judgment nobody likes. So sometimes there's a winner and a loser, and whenever you've got a case where there's a winner and a loser, quite often there's some payback into the future by the loser, because that's human nature. Quite often, even if both parties don't consider themselves to be losers, neither of them might be very happy with the outcome. And even if you're the winner, our experience shows us that sometimes when people have won a court case, they're still not happy. Why? Because it's cost them an awful lot of money, an awful lot of time, a huge amount of stress, and it's damaged the relationship irreparably. So we, at our firm, at Bell Perrier Clark, we strongly believe that court has to be an absolute last option. We know that court is necessary for some people, but it should always be the place of last resort, and every other sensible solution or process ought to be trialled before anyone considers going to court.
It's not uncommon for me when I initially meet a client that they may want what they think is an aggressive and combative approach to the dispute. Often people think that that's what's going to get a result. In my experience, it rarely achieves what you may be seeking. I often discuss with clients, if they believe the aggressive approach will work and they have found an aggressive lawyer who will adopt that approach for them, ask that lawyer to commit to writing what he or she can guarantee. Can they guarantee how long it will take? Can they guarantee how much it will cost? Can they guarantee an outcome? Can they guarantee levels of satisfaction? Any lawyer who is genuine with his or her client knows they can't guarantee almost any part of the court process. It is totally beyond that lawyer's control. It is totally beyond the party's control. Statistically, most matters do not result in a judgment. Most matters settle, and typically they settle a week or two out of the trial starting. Normally when parties are depleted, their energy is gone, they've spent a fortune on lawyers, they've had a gutful, they want to resolve it, they want to settle. They're typically settling in the worst sort of circumstances. They're stressed, they're unhappy, etc. With a collaborative approach, collaborative practitioners take the attitude that let's sit down and talk about it, not 2 years into the dispute when you've blown a lot of money on lawyers, a lot of energy on the dispute. Let's talk about it sooner rather than later. Most matters are going to require a negotiated settlement anyway, even if it's been started in court. For most people, the court option is the absolute last resort. The reality is, our own Chief Justice has acknowledged on a number of occasions that most lawyers could not afford court. Frankly, I could not afford to pay a lawyer to resolve disputes for me in a court. It's just too expensive, too uncertain, and too stressful. People often say to me, I just want what's fair, I want justice. Most court actions when they commence, each party believes they are correct. Each party believes they will succeed.
But judges are human beings. They don't always get it right. They don't have divine wisdom. And sometimes I tell my clients that just because you are telling the truth doesn't mean that the judge is going to see it that way. And sometimes people tell lies in such a convincing way that their case prevails. So don't assume that going to court will mean a just outcome for you, because we're dealing with human beings.
As part of my ongoing professional development, I often read court judgments. On many occasions, as I read through the judgment, I will think to myself, both of these parties commenced this battle, and I use that word intentionally, believing they would win. Typically, both have lost. For a matter to settle, the parties need to agree. To agree, each party needs to consider not only what they need and want, but also what the other party needs and wants. Most people, sensibly guided through disputes, are actually quite creative and positive as to resolving those disputes. Once we as humans get through the anger and the initial shock of a dispute, properly advised parties will achieve creative, sensible solutions. One of my frustrations over the years is that the court process often blocks that creativity and that respect. For most people, court should be the absolute last resort.